Right, let's bring in Fox senior judicial analyst Judge Andrew Napolitano. Judge, you think that this law is going to be essentially thrown out entirely?
Well, I do, John, just from the tenor of the justices during the oral argument. You know, an oral argument before the Supreme Court of the United States is not a test of the best lawyer. It's not a test of the law, and it's certainly not a game, particularly when the nation's eyes are watching. For Justice Kennedy to have asked the questions that he did in as early on in the argument as he did, in as sharp a way as he did, using a particular code word that he did, tells me that he has decided that this law is outside the confines of the Constitution. That's step number one. Step number two, of course, is what to do with the law. Do they invalidate just the parts that profoundly offend the Constitution, or do they decide that if they remove those parts, the rest of the law doesn't make any sense, and they might as well invalidate the whole thing? That is a process that the court will eventually come to a consensus on after it takes the initial votes, how they want to vote on the major issues, and then the justices who are assigned to write the opinions and dissents begin writing those opinions and dissents, and they begin circulating them among the other justices.
This thing was shepherded through Congress, or maybe rammed through Congress, under Nancy Pelosi as Speaker of the House. She has said a number of interesting things, including the fact that we have to pass this bill before we can find out what's in it.
Right.
She also asked whether, well, incredulously, she was asked whether this bill was constitutional. Here is an exact transcript of what she had to say. I believe we have it. At any rate, she said...
Madam Speaker, where specifically does the Constitution grant Congress the authority to enact an individual health insurance mandate?
Are you serious?
Yeah.
Are you serious?
Yes, I am.
We knew what we were doing when we passed this bill. It is ironclad constitutionally. What happens in the courts is another matter.
Okay, so ironclad constitutionally, but maybe not according to the Supreme Court?
Well, in fairness to her, I think she's speaking as a politician, not as a lawyer, and not as a legal scholar. But I remember we interrogated Congressman Jim Clyburn, the number 3 ranking Democrat. Where in the Constitution is the federal government authorized to manage health care? He looked at me and he goes, Judge, most of what we do down here is not authorized by the Constitution. They are simply concerned with staying in power and with bringing home the bacon. They are not concerned with whether or not what they do is authorized by the supreme law of the land. I think that Mrs. Pelosi will be unhappily surprised when we learn finally how the Supreme Court comes down on this in June. But for her to suggest that there isn't even a constitutional argument to be made reveals an embarrassing indifference or ignorance on her part.
There have been an awful lot of suggestions, primarily from the left, from talking heads on television and so forth, that if this court strikes down the law, it is going to be legislating. It's going to be writing law and maybe subverting the will of Congress. I suppose that last one could be accurate, but legislating?
Well, you know, that's an argument that both sides of the aisle make when a statute that they like is overturned. But think about it. The Supreme Court is the anti-democratic branch of the government. Its whole purpose is to assure that the Constitution is enforced, even when the majority is wrong. If we didn't have a system like this, then nothing could prevent a runaway majority in the Congress from taking the liberty or the property or the lives of whomever they wanted to take.
Well, the good news about all of this to me is that it has been a fascinating lesson in history and the workings of the Constitution and co-equal branches of government.